Good afternoon. My name is Preet Bharara, and I am the U.S. Attorney for the Southern District of New York. Under authority of the False Claims Act and other laws, the government today sues Deutsche Bank and its wholly owned subsidiary, Mortgage It, for years of reckless lending practices. As alleged, these companies repeatedly and brazenly breached the public trust. This lawsuit sends them and other lenders the message that they cannot get away with lies and recklessness. They cannot casually assign the prospect of being caught to the cost of doing business. Accordingly, with this lawsuit, the government is seeking treble damages, the maximum civil penalties, future damages, and punitive damages for a pattern of reckless lending practices, a pattern that occurred over a period of years and all over the country. The complaint describes in detail lenders taking abusive advantage of a vital government mortgage insurance program, issuing billions in loans to countless aspiring homeowners. But while the homes the defendants issued loans for may have been built on solid ground, the defendants' lending practices were built on quicksand. Borrower after borrower defaulted, often within just months of closing, because those loans were doomed to fail. Why? Because, as alleged, the defendants simply ignored every type of red flag and breached every duty of due diligence before endorsing mortgages for federal insurance. In fact, they often seem to treat red flags as if they were green lights. Ultimately, prudence was trumped by profit, and good faith took a backseat to good fees. And today, we hope, that calculus changes. Before I go any further, let me introduce and thank the partners standing with us today. They are Dane Narode, the Associate General Counsel of HUD's Office of Program Enforcement, and Renee Feblis, Special Agent in charge of the HUD Office of Inspector General in New York. I'm also joined by members of my office's Civil Frauds Unit, which oversees our civil frauds investigations, including mortgage fraud investigations like this one, and which is handling this suit. And they are Assistant U.S. Attorneys Brian Feldman, along with Chief of the Civil Frauds Unit, Heidi Wendell, and Deputy Chief Lara Eshkenazi, and I also want to thank Paralegal David Farber. Now, some of you may know I established the Civil Frauds Unit about a year ago to bring renewed focus and additional resources to combating financial fraud, including the type of fraud that we charge in this case today. Now, let me take a minute and go back to explain the allegations in the complaint that was filed this morning. In order to understand the nature and significance of the allegations, it's important to understand what the Direct Endorsement Lending Program is, which was run by the Department of Housing and Urban Development, HUD, which includes the Federal Housing Administration, or FHA. In a nutshell, here's how it worked. The program depends on direct endorsement lenders, whom the government entrusts with an essential public duty. These lenders are deputized to approve or endorse mortgages for insurance. In exchange, their job is to review mortgages to determine whether the risks exceed government standards. They make a promise that every loan they endorse complies with HUD rules aimed at ensuring that the homeowners can realistically make their mortgage payments. These mortgages are then insured by the federal government against default. In order to qualify for this privileged status as a direct endorsement lender, financial institutions must meet quality control standards, commit to due diligence, and certify the quality of each and every mortgage they endorse. But as today's lawsuit describes, the defendants never held up their end of the bargain. Neither Mortgage It, when it was acting alone from 1999 to 2006, nor Deutsche Bank when it acquired Mortgage It and carried on its business until 2009. Instead, they indulged in the worst of the industry's reckless lending practices. While they promised to select qualified mortgages to be insured, they repeatedly abused the public trust by brushing aside the rules, lying about the quality of their underwriting operation, and passing on the costs of the inevitable hundreds of millions of dollars of defaults to the government. It wasn't their problem anymore. The government held all the risks and ultimately was left holding the bag. More than 14,000 of these bad loans ultimately defaulted. As a result, the government has so far paid more than $3,100 insurance claims totaling some $386 million. Of that amount, nearly $100 million was paid for more than 600 mortgages that defaulted within just 6 months of closing. And the government will be forced to pay even more in the future, as Mortgagit endorsed more than 39,000 mortgages for government insurance in total, totaling more than $5 billion in underlying loans. As we allege, the corporate culture led to the collapse of lending standards. Most tellingly, the defendants repeatedly lied to HUD about the implementation of quality control standards. Their recklessness is very well documented in the complaint that was filed this morning. If you take a look at the chart to my left, it cites to various paragraphs in the complaint. I won't go through all of them, but one is typical, found in the complaint at paragraph 20. Quote, by the end of 2007, not a single person at Deutsche Bank or Mortgagit was conducting quality control reviews of closed FHA-insured mortgages as required by HUD rules. Let me further mention just 3 quick examples specifically of the type of recklessness we are talking about. First, a critical part of quality control for lending is the review of early payment defaults. If borrowers are defaulting right away, say within 6 months, that is a critical red flag. Review of those red flags is an early warning system for problems in the underwriting process, which only makes sense, as early defaults are an indicator of possible mortgage fraud. That's not only simple common sense, it was also mandatory. That kind of review was mandatory for participation in the insurance program we're talking about here. But as alleged, Mortgagit utterly failed to review early payment defaults. That failure, of course, helped to perpetuate a pattern of defaults going forward. Second, Mortgagit blithely ignored red flags in the form of outside audit reports. As set out in the complaint, an employee of Mortgagit had repeatedly signed off on shoddy loans which were not eligible for federal insurance. An outside auditor finally called attention to her practices. But that auditor's findings were remarkably stuffed in a closet, unopened, and still sealed for months. And even after a new manager finally found the proverbial skeleton in the closet and read it, upper management still did nothing. Third and finally, as specified, Mortgagit often did not undertake even the most basic forms of due diligence. For example, like confirming that the borrower had a job. In one case, documented in the complaint, a borrower defaulted just 4 months after the closing. That shouldn't come as too much of a surprise because it turns out, as alleged, that the borrower never worked for the listed employer. But Mortgagit never bothered to pick up the phone. In short, this reckless behavior, the failure to implement the lending standards required by the FHA program, led the government to foot the bill for many, many mortgages that were doomed to fail, mortgages that were really ticking time bombs. Now, the FHA is a vital program, and direct endorsement lenders are absolutely critical to its success. The work they do is important to ensuring that millions of Americans can purchase homes. And that is why lawsuits like the one that was filed today are so important. They're just as important to ensuring the future strength of the mortgage market as they are to punishing past abuses in that market. The Federal Housing Administration, as you may know, or you may not, is the largest insurer of mortgages in the world, and its market share is only increasing. In fact, FHA currently insures 1 out of every 3 new residential mortgages in America. That's up from just 4 or 5 out of every 100 only a few years ago. That means that FHA is becoming a more important pillar of the entire housing market. And that, in turn, means that the type of cheating and churning described in today's lawsuit is simply unacceptable going forward. Every lender in America needs to be on notice that more than ever before, we cannot tolerate fraud and misconduct in the mortgage market. In order to prevent another crisis tomorrow, we all need to be even more vigilant today. Now it is my pleasure to call to the podium Dane Narode, the Associate General Counsel of HUD's Office of Program Enforcement.